SJC-11529, Commonwealth v. Manuel Andrade.
Great. So as you get yourself together, we'll hear from you, Attorney Scapicio. Absolutely.
Good morning, Your Honors. May it please the court. My name is Rosemary Scapicio, and I represent Manny Andrade in this appeal of his conviction for first-degree murder. There are a number of issues in my brief. There are three that I would like to cover today. The first is the inconsistent arguments in the Brady violation. The second is the closed courtroom issue. And the third is the Santiago instruction, which we say all, either individually or combined, resulted in an unfair trial for Mr. Andrade. Now, with respect to the inconsistent argument, this was a case where there were two defendants. The case was severed. Mr. Barros, who was the co-defendant, went first. In Barros's trial, the Commonwealth, the same DA who represented the Commonwealth in Mr. Andrade's case, elicited information that suggested that the car that Mr. Andrade was in was moving at the time it was fired on, and that Andrade returned fire. That's what they said to the Barros jury to try to convict Barros of first-degree murder. When it came time for Mr. Andrade's trial, they changed their theory. In the core of their theory, they now said that Mr. Andrade was standing outside of the car and the car was stationary, or either the car was moving or the shooter was moving at the time that the shots were fired.
Counsel, I don't mean to interrupt you, but with respect to that, though, in either of the trials, the theory at root was still that these two were engaged in a gunfire, in a gun battle. I know that you're saying that in one they said the car might have been moving, but the central component that these two were firing at one another, and therefore that's what the both were being argued at both trials.
Not exactly, Your Honor, and let me explain why. So in the Barros trial, it was important for the Commonwealth to present a theory in which Barros was the aggressor, Barros fired first, and Andrade returned fire. In order to convict Andrade at a separate trial, the Commonwealth had to allege that Andrade was outside of the car at the time that the shots were fired, because if he was merely responding to a shot that was fired at him, as they had told the Barros jury, then we would have been entitled to a self-defense instruction. There would have been mitigation, and he wouldn't have been convicted of first-degree murder. So it's not just that there was a gunfight. It was the manner in which they portrayed the gunfight that was problematic. And it was problematic because the only way they could get a Santiago instruction is if they claimed that this was one continuous act. And that's what they tried to do at the Andrade trial. While at the Barros trial, they claimed there was a shooting of Barboza, that my client Andrade was leaving the premises, retreating to his car, got in his car, the car started moving, and then was fired upon. That's not a shootout. That's not a shootout at all. And even if you want to believe that Mr. Andrade pulled a weapon on Mr. Barros, under Colas, which this court just decided 2 weeks ago, aiming a weapon at someone is not a shootout. So where is it that the shootout starts? In the Barros case, the shootout started when they claimed that Barros fired upon the moving car. And not just claimed that, but they had their expert. They had a trajectory expert who testified at trial. And the hypothetical that was presented to the expert at the Barros trial was assuming the car was moving, and the shooter was stationary. That was the Barros trial. Now you move on to Andrade, and the assumption by the same prosecutor with the same expert is assume either the car is moving or the shooter is moving. And that's important because if we were able to tell our jury that in a separate trial to convict a different defendant, they claimed the car was moving, that would have made a huge impact on whether or not the Commonwealth ever even would have got a Santiago instruction to be able to prove any type of intent on behalf of my client. And so it's very important that not only did the Commonwealth change theories in terms of what they were doing from trial 1 to trial 2, but they actually elicited the opposite information from their expert, and then
I'm
didn't tell us
confused,
about it.
though. Doesn't,
So
your client fires, we have, you're leaving out sort of the initial part of this, right? Which is your client, there's evidence that your client shot Barboza inside 415 Geneva Avenue.
That's
before
correct.
So I don't know how your self-defense works when your point is you're somehow deprived of a self-defense argument because of the way they did this. But your client, this isn't the Colas case. Your client shot before this all begins, right? Don't we have to take that into account?
Well, it depends on how you take it into account, Your Honor. So
Mhm.
this is what the problem is with that argument. So
Mhm.
if you're saying it's the same continuous event and Mr. Andrade fired at Mr. Barboza, Barboza isn't the one who fires back at Andrade. That's not what happens here. A completely separate person, Mr. Barros, fires at Andrade. So when Mr. Barros fires at Andrade, Andrade has a right, at least in terms of mitigation, to tell the jury that at a last trial, the Commonwealth had a completely different theory about how this crime happened. So when you say he started it, even if you
Well,
believe that, if you believe he started it in
We're
the house.
not dealing with a case in which we don't have a shootout. We have, your client shoots Barboza, then the other guy comes out and shoots at your client, and then, you know, your client fires back. I mean, it's not the case we just decided where somebody fires a gun and it's not even clear that the defendant fired or did anything but point a gun in the air, right? We got a
Well,
different.
that's the whole point here, and I don't mean to interrupt, but
Mhm.
there were 4 passengers in that car, other than Mr. Andrade. 3 of them testified at trial, and all 3 of them said, never saw Andrade with a gun, never saw Andrade fire a weapon. The jury was free to believe that and disbelieve Nunez, who said Andrade had a gun and was fired. And if the jury believed those witnesses who had no skin in the game at that point, their friend had been killed. 2 of the witnesses said, never saw Andrade fire a weapon. One of them initially said the car had been moving at the time that the shots were fired. And then there was another witness who said the only reason that Andrade had turned around is because he heard someone yell, pop him, and he was warning Andrade to look out and had warned everyone else in the car to duck. So if the jury believed that scenario, then that's not one continuous event. Those are 2 separate events. Barros had no right to take revenge on Andrade. Andrade could not have anticipated that someone other than Barboza would fire back. This isn't a situation where this court would ever say that if I shot at somebody, then another person has the right to shoot at me. This court has never said that. And in order to make this theory fit, that's what has to happen here. It can't be that there is the shooting in the house and my client is retreating from that. And then a whole different person comes up and starts firing. When that person starts firing, that's where the mitigation comes in. Either it's sudden combat or heat of passion at that point, or self-defense, all of which were taken away from us by the way the Commonwealth tried this case.
Well, let's talk about that for a second, because at least with respect, not necessarily the mitigation, but the self-defense component of it. The trial counsel was specifically asked, and so was your client, whether or not they wanted a self-defense instruction. And trial counsel represented to the court that Mr. Andrade did not, and then the court inquired directly of Mr. Andrade, who also said the same thing. And then the other things about the way the case was presented in Mr. Barrow's trial, weren't all the transcripts turned over to Mr. Andrade? Didn't he have all of the information about who argued there and what would the witness testimony?
No, the problem was that the Barrows trial ended on February 27th. The Andrade trial started on March 19th.
But
There was not
counsel,
enough time.
sometimes people watch those trials when they're related to another trial.
And isn't there evidence that Mr. Andrade's counsel sat through Mr. Barrow's?
I was Mr. Andrade's counsel.
Oh, pardon me.
So-
But didn't you sit through?
Yes, but let me just explain that. The Commonwealth is not relieved of its due diligence obligation under Brady simply because they think the defendant might know something. And to sit in a trial in and out all day doesn't necessarily give you the same flavor of what the transcripts would give you in this case. And so there's a Third Circuit case that I'd like to bring to the court's attention about this due diligence argument. And the case is Dennis versus Secretary. It's 843 Fed 3rd 263, 2016 case, which says essentially the Commonwealth is not relieved of their obligation under due diligence under Brady, just because they think that the defendant might know what's going on. And further, I think the court said that the defendant's not obligated to scavenge for hints of undisclosed Brady information. This was, I mean, as far as the expert was concerned, it was an expert. I was entitled to an opinion that impeached him. But more than that, it was a statement of a witness that I was clearly entitled to. And if I don't sit through the expert testimony and find out what the expert says, how am I supposed to find that out before I go to trial 3 weeks later? I can't know that unless the Commonwealth tells me. And the Commonwealth in this case isn't telling me because they know that if I know that, I'm going to use it at the trial and the theory would be imploded. So what we have to prove in terms of inconsistency is that first there was factual inconsistencies, which clearly there were, and that it went to the core of the case, that this wasn't just a witness making a mistake. And it's not just a witness making a mistake. In this case, when you have the same prosecutor arguing two different things to two different juries to convict two different defendants of the same crime, that's a due process violation. That's clear. And I think this court said that in Keogh when they referred to Commonwealth versus Higgin, where you said use of factually contradictory theories against different defendants for the same crime violates the principles of due process. That's exactly what happened here. There was use of contradictory evidence elicited by the Commonwealth to convict two different defendants of the same crime, if they didn't have that trajectory analysis. And just so we're clear on what the prosecutor did in this case, not only did he switch theories, but when I went to cross-examine the expert about whether or not the car was moving or the car wasn't moving, the prosecutor went one step further and in closing argument told the jury, it didn't matter if the car was moving. That's not the point here. And in fact, it was the whole point that the car was moving. Because if the car is moving, my client's in it. And if my client's in it, then he's not standing like Nunez said and shooting back. And they never could have got a Santiago instruction based on that. They couldn't have. And that's why it went to the core of what happened here. That's why it's a violation of due process, in addition to being a violation of the Brady information. So under Brady, we proved here that it was exculpatory, because clearly it's an opposite opinion from an expert. And we're not even getting to Jessica Nunez at this point, that it was withheld and it was prejudicial. We've proven all of that in this case, which should require the reversal of Mr. Andrade's conviction. Now, I know this court talked about Colas and said that this case is different from Colas, but I think if you break it up compartmentally, it's not much different from Colas in terms of the allegation that my client pointed a weapon at Mr. Barros. If you believe that alone, A, you don't know if Barros saw it because Barros didn't testify, so you don't know if he saw it. B, you don't know at that point what he thinks Barros has, because Barros hasn't done anything at that point. You would think that if Barros was going to retaliate for Barbosa's shooting, he would have pulled out his gun and did it right there, but that didn't happen.
So, you're limiting, I'm just trying to understand that because it just seems strange to me. So your client starts a shootout inside the building. He shoots one guy, the guy's friend comes out and shoots him. Your view, that's not a shootout under Santiago. No. I'm accepting some of your arguments about inconsistent. That's not a shootout, really? That's not a shootout. So I can go shoot somebody and not expect their friends to come out firing at me. I mean, it's that we've said that in cases. That's not a Santiago shootout.
Well, if this was a gang case, which we tried to introduce gang evidence.
Well, we don't need it to be a gang case. People have friends. People have. You shoot.
As a defendant, Mr. Andrade is supposed to, if he's involved in that shooting, you have to remember that shooting is also contradictory evidence about that shooting. The shooting inside was that somebody was holding a bottle over Andrade's head, that somebody else was there in an altercation with Andrade, and then a shot was fired.
Yeah, but we look at this in the light most favorable to the Commonwealth. We don't look at it in the light most favorable to you. And there's clear testimony that your client shot someone inside. And then one of the guy's friends came out firing at your client.
He didn't have
that's
the
a
right to
shootout.
fire at that point. If my client was retreating, nobody here would say he had the right to fire upon him. And that's exactly the scenario that the Commonwealth presented in Barrows.
Well,
My
it's
client
not-
was retreating. He had nothing. There was nothing for him to take revenge on. If he was acting in self-defense, he had time to cool off. If he was shooting because he thought someone shot his friend, how is that a shootout for my client if my client is in the car driving away? It can't be a shootout.
The question is your client responsible for starting a shootout that results in somebody else getting shot? And I don't see
think
how
that's the
you're.
question. I think the question here is whether or not it's one continuous act. And the Commonwealth said for the purposes of the Santiago instruction, it was one continuous act. And then for the purposes of sentencing, they changed their mind and said it was separate acts. And then in Barrows, they were saying it was completely separate acts because my client was in a position to fire back. So imagine this jury, the Andrade jury, if they were able to learn in this case that the very last case that the Commonwealth had on these facts alone, that the Commonwealth had alleged that my client fired back, returned fire. He wasn't standing in the middle of the street. He was in a car retreating. They wouldn't have got the Santiago instruction. That's not a shootout. And that's part of the argument that I wanted to make that I know I'm running out of time for on Santiago. How do you define a shootout? How do you define it? Can you shoot someone one day and then the next day someone comes and shoots you? Is that too long of a period of time? So what is a shootout? Does a shootout encompass somebody who is retreating? Because that's not defined.
How much time passes here? How much time passes here between this, again, the light most favorable of the Commonwealth, between your client shooting someone inside Geneva Street and the second set of bullets fired in the opposite direction? How much time passes?
In the light most favorable of the Commonwealth, about a minute and a half.
Okay, so that's different from 2 days later, isn't it?
But you would say if this was a self-defense case and Barrows was arguing self-defense, you would say he had no right to do anything at that point because there was time for him to do other things to make himself safe.
But you're
And so
not
the fact that he decided
representing
his own-
Barrows. You're not representing Barrows. You're not representing Barrows. You're representing Andrade, right?
Andrade, right.
Mhm. Okay.
But I'm saying that you wouldn't be able to make this argument if you were talking about Andrade. So if Andrade doesn't have a right to go out and continue this fight or start a new fight, then it's not a shootout. And that's the problem with the Santiago instruction, is that it's not defined in the way that it should be.
Counsel, could I ask you about Andrade's trial?
Yes.
Was evidence presented for the defense consistent with what you're saying the Commonwealth argued at Barrows's trial? That is, that Mr. Andrade was in the car and was shot at.
No. We tried to get that evidence out through one of the friends of the victim who was actually in the car. He had initially said the car was going for a period of time. I think he said a minute in some seconds before it was fired upon. But he did not recall having said that at our trial. So no, there was no evidence of Mr. Andrade retreating, other than the fact that he was shot in the rear end. And we tried to make some evidence of that with the medical examiner about how that shot could have happened if he was standing in the middle of the street, as the Commonwealth had alleged in the Andrade trial.
And then how do we factor in the conscious decision to not take advantage of the trial judge's offer to give the self-defense instruction?
Because the trial judge had previously said he's not giving a self-defense instruction. It wasn't an offer. He had already made a determination that he wasn't giving a self-defense instruction, and that's contained in my reply brief, exactly where he says that.
Well,
And
what do we make of the transcript then when what's the point of asking you and Mr. Andrade whether or not you wish to have a self-defense instruction?
The point at that point, I don't know what was in Judge Gaziano's mind. I have no idea what was in the trial judge's mind at that point. But he had already told us that we weren't getting a self-defense instruction. He said those words to us before we ever did anything. So at that point, I was trying to make a determination as to whether or not my client was going to testify. There had been a decision that I wasn't getting a self-defense instruction. My client didn't testify. I had no reason to believe that the judge was going to change his opinion of whether or not self-defense was there. But it's not just self-defense, it's mitigation.
Sure.
And if you look at the mitigation, one of the issues that we raised is this legally inconsistent theory where the whole premise under Santiago of how Andrade gets convicted of first-degree murder is that he intended to murder Barros. But the jury only finds him guilty of assault with intent to kill. So they found mitigation with respect to the intent to murder Barros, but not mitigation with respect to the first-degree murder for Mr. Andrade. And it's the same crime, it's the same mitigation. But they didn't find it with respect to the first-degree murder. So we're saying that's legally inconsistent. I know my time is running out. I just do want to touch on two quick issues, if I may, Your Honor. The first is the closed courtroom issue. This is a case where, over my objection, the trial judge set up a desk outside of the courtroom and required people to present identification before they came into the court. There are at least 7 people who filed affidavits that are contained in the record appendix that suggest they weren't allowed in because they didn't have any identification. We don't find out about that until 2011. We file a motion for a new trial. It gets denied without an evidentiary hearing because the Commonwealth says we don't need an evidentiary hearing. This court has never said, ever, that having identification is a prerequisite to walking into a courtroom in terms of a Sixth Amendment right to a public trial. This is a different scenario from Maldonado, which the Commonwealth says is dispositive of this case. In Maldonado, what this court said was essentially, yes, you could ask someone for their identification to make sure they're not on a witness list and they need to be sequestered, but you can't ask them for identification and then exclude them if they don't have it. Maldonado never said that. And that's what the Commonwealth is asking the court to do in this case, to say an actual closing of the courtroom, seven potential public members who wanted to get in, who didn't get in. At a minimum, it's a partial closure. It's a structural error, and it requires reversal of Mr. Andrade's conviction. And then the final thing is the Santiago instruction. And again, I don't want to repeat anything, but we're saying the Santiago instruction in and of itself was a violation of due process because it failed to adequately regulate the fact finder's discretion. It was standardless, and it was injected into the instruction on first-degree murder. So Santiago, in terms of causation, what the court said to the jurors in our case is that if you believe that there was a shootout, that's enough for first-degree murder. And this court has never said that, has never said that. But that's the way it was presented to the jury. And specifically, if you look at page, I think it's volume 12, page 100, what the court said to the jurors is that an act which in the natural and continuous sequence results in death and without which death would not occur is the cause of death. The defendant's act need not be the sole or exclusive cause of death. The Commonwealth is not required to prove that the defendant fired the fatal shot in order to find the defendant guilty of first-degree murder. By choosing to engage in a shootout, a defendant may be the cause of the shootout by either side, and the death of a bystander is a natural result of the shootout. Now, this insertion of guilty of first-degree murder, that's not what Santiago says. What Santiago says is you don't get a pass on a homicide because you're in a shootout and they can't prove who fired the fatal bullet. This court has never said that it's enough to prove first-degree murder. And that's essentially what the court said to them under these circumstances. We're suggesting that the Santiago instruction is a constructive malice problem, that there's vicarious liability, that there's approximate cause theory, and that it is so approximate cause, vicarious liability, constructive malice, and conclusive presumption of intent. Those are all the major problems with this Santiago instruction because things are undefined, because the jury's, the ability of the jury to look at whatever they wanted to was not prescribed in any way. And with that, if there are no additional questions, I would rest on my brief.
Thank you.
Thank you, Your Honor, and thank you for the additional time.
Okay, Attorney Cilio. Can we start with the jury instruction issue on the Santiago instruction?
Sure, and may it please the court. My name is Kathleen Cilio. I'm representing the Commonwealth. And just before I start, I just want to acknowledge the victim's family who will be watching here. In addition, the Assistant District Attorney Edmund Zaman, who is the trial attorney, and Aaron Knight, who is on the brief, and thank you. Regarding the Santiago instruction, as this This is an instruction on causation, not intent. This court made it clear in Santiago, and I think Colas highlights that as well, that this goes to causation. That's how the jury was instructed as to causation. They also were instructed that they had to prove that the defendant actually intended to cause the death of his alleged target, which was Casimiro Barros, and he did so with deliberate premeditation. What Santiago allowed was that the defendant's act of firing at Barros outside 415 Geneva Ave, that he could be the cause of Miss Levin's death as she was waiting in that Cadillac. And I just want to, and unless this court has any questions regarding the appropriateness of the Santiago instruction, I'll just move to the inconsistent theories that Ms. Capiccio spent her time with. I just want to point to a couple of citations in the record. First, Your Honor, I think brought up, Ms. Capiccio conceitedly said she sat through Barros's trial. That's on the 18th of March on page 12. There was also references in the transcripts of the party, I mean, in the Andrade transcripts of them having the prior testimony of the witnesses. The judge referenced that, I believe, in some of his pretrial motions regarding whether or not he was going to allow Sergeant Detective Dugan testify regarding the glass, his view of whether or not the window was open or closed in the Escalade. He said, I have to look at the transcripts and see what his testimony was during that. During Jessica Nunez's testimony, I believe the trial prosecutor referenced the transcripts and having her, looking to her prior testimony in Mr. Barros's trial. And I believe at least in another witness, and I have those citations in my brief regarding the fact that they had the transcripts on that. And just turning, Your Honors, just to—
Can I just ask you to be clear, when you say they had the transcripts, you mean defense counsel had the transcript?
Yeah, so to be clear, the judge referenced transcripts. I don't remember if in any of the trial testimony, counsel used it or not, but I know the trial prosecutor had it, and I just could not imagine a situation where the judge had transcripts and the prosecutor had transcripts and defense counsel didn't have transcripts. So I do not believe—
Isn't that the Brady violation?
I believe that would have been raised at trial, Your Honor, regarding the judge having transcripts, the prosecutor having transcripts, and defense counsel not having a transcript.
Counsel, arguably those transcripts would have been available to anybody who was seeking transcripts. Is that right? So they're not under your control?
Correct. Those came from the prior trial, which counsel sat through. So counsel had the opportunity to cross-examine any of the witnesses in which she felt that was misleading the jury regarding the facts. The facts remain the same, substantially the same in both trials. It's borne out in the closing arguments of the assistant district attorney. 2 men were responsible for the murder of Kiara Levin. He certainly marshaled the evidence differently. Barros's was an act of retaliation. The defendant was started at when he went inside 415 Geneva Ave and he shot Barbosa, pulled the gun on Barros,
Can
and
I
then
just
engaged in the
stop you
shooting.
for a second? I just want to be clear. Are you saying that the prosecutor disclosed the expert's witness statements given during the Barros trial? Is that what are you representing that happened?
The expert testified at Barros's trial.
Yes.
All the exhibits were the same from Barros. That was an issue obviously raised. The same exhibits were used at Barros's trial as Andrade's trial. That's
Right, and
a
I guess
claim.
my question is, are you representing that the prosecutor disclosed the witness statement of the expert given during the Barros trial in connection with the Andrade case? Or are you relying on the fact that counsel sat in?
Correct, and that there are references.
That counsel sitting in during the Barros trial excuses the Brady obligation of the prosecutor to disclose witness statements, which, as you know, are required to be disclosed.
So there was actually an interchange during another witness where the judge, she brought up I believe it was in Sergeant Detective Dugan's testimony, and I don't have the exact site, where complained about the lack of disclosure of something else. I'm saying unrelated. And Judge Gaziano said, did you sit through this testimony? Were you aware of this testimony? Yes, I was. And he said, there's no prejudice to you. And that is, so I'm gleaning from the transcripts, Your Honor, but I think it's a fair, accurate representation of what was going on, Your Honor, that Ms. Capicio sat through Mr. Barros's trial, that there were transcripts, and there was access to this, the expert, and this is,
Your position, I think your position, as I understand it, is that even if there was a failure to disclose the prior witness statements, i.e. the transcripts from the Barros trial, it did not inure to the prejudice of the defendant because his counsel had actually sat in.
yeah, and also I just want to be clear too, what she's referring to in terms of the expert, it was not raised, Ms. Capicio did not raise that he was testifying to something different than what she had notice of. That did not come out in Andrade's trial. What she's, and obviously in the defendant's record appendix, there is the closing argument of Mr. Barros, of the trial prosecutor's closing in Mr. Barros's trial. There, I just went through it again. Maybe I misread something. There's no reference of the Cadillac moving. There's a reference to Mr. Andrade moving, which was consistent with him backpedaling, which was consistent. And that comes from Jessica Nunez's testimony in both trials, that he was moving backwards, but there was no testimony, there was no allegation that the car was moving. What was of import of the trajectory analysis, I don't even know if I'm saying that right, trajectory expert, was he gave a range starting from the Pathfinder that had the 380 bullet found in it. He gave a range based on his analysis, based on the height and the angle in which the bullet went into the Pathfinder of where the shooter possibly could have been and at what angle the shooter would have been firing at certain heights of the shooter. And that was the import of that trajectory analyst. It was not whether or not the car was moving. And it's clear based on the closing argument of Mr. Zabin as well, and he made that clear.
Can I ask
So just to
about
put it in
this?
my legal box, you're saying that there is no prejudice because it didn't matter whether or not the Andrade was in the vehicle moving or whether he was backpedaling.
Yeah, I actually think factually, the issue, what we relied upon or referenced was Andrade moving backwards, not necessarily whether or not the car was moving. Mr. Andrade was shot outside the car. There was a bullet hole. If you look at, there was a bullet that went through, I believe at least the front passenger seat. There was a bullet hole that went through there. So it was always our contention in both trials that Mr. Andrade fired from the area of the waiting Cadillac, which was corroborated by numerous witnesses as well. And so our theory never changed. We definitely emphasized each person's involvement at different points in the different trials, but that would be expected in a situation where there are severed trials. If this court has no further questions on that, I'll move quickly to the ID issue. So and I just want to draw this court's attention to a case that actually wasn't in my brief, and I will provide it to the court. It's Commonwealth versus Ray, which is 467 Mass 115. It was decided after Maldonado. And similar to this case was a case that was tried prior to Maldonado, which is what the court did not have the benefit of Maldonado. And so this court said in Maldonado, there are certain things that the trial judge should do going forward, which is, I think, very fair when you have such a condition of entry, such as requiring a photograph. First is whether or not it should be mandatory or not, and whether or not what would happen if someone couldn't enter. And so this court has said that, and I think it's wise, right? But going back then to the trial that occurred in 2009, and see, what we're looking at then is whether there was an articulable risk of witness intimidation and whether or not it was no broader than necessary. And that is whether or not then this court can see whether or not the judge abused his discretion in requiring this condition of entry. And so it really is borne out on the 18th of March, which is when the Commonwealth filed its motion. It actually filed the motion with a 5-page affidavit of Sergeant Dugan.
So
who
what
was
are the
present at the
security,
prior-
what are the security concerns? Because we've approved, I mean, you don't cite it, in Commonwealth versus Fernandez, we approved an approved list. You know, we've gone further if the security conditions justify it. But what are the security conditions here that justify the ID to go into court? What are they?
So that was articulated by the prosecutor, who was relying on the affidavit that was actually in paper number 76 in the docket. That there was a number of things involving a concern about witness intimidation. That was on page 3. And there was actually an incident at the prior trial involving 2 women who were believed to be related to this defendant, who, and it goes on to page 4 and then 5, about how they were trying to actually intimidate a witness who was Carlos Barros. That actually was brought to the prosecutor's attention during that, the prior trial. It brought to Judge McAvoy's attention. That was on page 4. And so there were then certain procedures set in place, and that sign-in procedure. So there was to be sure, there was a lot of reluctant witnesses in this trial as well. And that's borne out of the testimony. Jessica Nunez had to testify, had to receive certain payments for relocation. So there was definitely, it was tense. And there was a specific incident at the prior trial that gave rise for the Commonwealth to ask for the additional security in the courthouse and for the condition of entry. And based on that, the court was within his discretion to impose that.
So was it just they had to show ID, or was there a list of people that were not allowed in?
No, it was just to show ID.
So what was the purpose of having people show ID?
So the prosecutor actually articulated it well, that there was some of the witnesses were fearful for retribution from their testimony, and that so then by ensuring that the court would know who was there, or that that individuals had to identify themselves, then that would give them specific security in testifying. And that was specifically articulated, and as I said, articulated in Sergeant Detective Dugan's affidavit, which the
Now,
court had.
but counsel, if people were, as Attorney Scarpiccio mentions, that she has affidavits that are the same, that if just folks off the street that had a right to be in the public courtroom to go and observe this, who just didn't happen to have their IDs on them that day, were then turned away, isn't that problematic?
So actually, this court addressed it in footnote 7 of Ray, and again, I will provide the court with the site of it. As I said, it's 467 Mass 115, and it was in the same scenario that affidavits were submitted by the defendant afterwards, saying that they were not able to get in. And this court said the fact that some individuals may have been excluded from the courtroom does not in and of itself suggest that the condition was overly broad. So in some ways, the sign-in procedure, which is not a courtroom closure, this court said that in Maldonado, is not a courtroom closure issue. I think that is relevant to whether or not it was overbroad or not. It wasn't here. I would just also raise that the affidavits counsel said, she had them in 2011. She filed her motion for a new trial in 2018, after even the trial judge left the Superior Court bench. So it's very hard to say that the court abuses discretion when that was even never raised for him to be able to remedy it at the time too, which Maldonado takes care of what the court could be concerned of here, because it instructs in the future for the judge to make it to instruct the court officers to maybe only make it preferable, not a condition, not a set condition, mandatory, but also to figure out with counsels and the court staff what happened if someone doesn't have it, and to raise that to the judge, because I think it needs to be raised to the judge at the time so the judge can remedy it.
Okay, but that you can't use that here, right? Because counsel said she didn't know it was going on.
Correct, Your Honor. So what we're looking at, and I this is why it's to cite to Ray, it really is only whether or not it is too overbroad. That's the relevance of it. because it's not a closure. This is what the court said. You're just looking at whether or not he abused his discretion. And so there's other remedial tasks that this court has now asked trial judges to do if they impose it. But because 9 years later, she produces affidavits that say, I wasn't allowed in, it doesn't mean the court abused its discretion back in 2009 to impose this condition of entry.
But wasn't it obvious that some people might not have their ID? Wasn't that an obvious potential?
Correct, and this court considered that in Maldonado and Ray and knew that it could actually be a consequence. And that's why in Maldonado, it talked about going in the future, this is what judges could do to try to make sure that if people, so that the court staff really who are sitting outside could bring it to someone's attention. And so that is what the court has said in Maldonado, and that was obviously perspective. So really what this court is looking at is whether or not the judge abused his discretion in allowing this condition of entry. And your honors, if you have no further questions regarding anything in the Commonwealth's brief, the Commonwealth would respectfully ask you to affirm the defendant's conviction of first-degree murder and for the other convictions for his participation in the shootout outside 415 Geneva Ave. And I thank you for your time.